Advocate RNC. Mr. Chetty, good morning. Good morning to you. Your microphone was not on. If it is green, it means it's not on. It must be red so that whatever you say goes into the records. Good morning to you.
Good morning, Chairperson.
Yeah, thank you so much. We are going to administer oath on you so that whatever information or evidence that you give us is recorded under oath. But before we do that, let me say the following to you, that you have been invited here before this ad hoc committee which investigates the allegations that were made by the KwaZulu-Natal Provincial Commissioner, General Nhlanhla Mkhwanazi, with the belief that the information that you are going to give us shall help the committee in its oversight and investigative work. The allegations include, amongst others, number one, the alleged unlawful disbandment of the Political Killings Task Team, otherwise known as the PKTT or the NPKTT. Number two, alleged moratorium on the filling of vacancies within the South African Police Services, the SAPS. And number three, alleged corrupt relationship between the SAPS senior leadership and members of the public. And lastly, number four, alleged political interference in the work of the SAPS. In extending the invitation to you, the chairperson of the ad hoc committee has indicated to you that you may provide such information to the committee if you so wish, under oath, in terms of the powers, privileges, immunities of Parliament and Provincial Legislatures Act of 2004. Mr. Chetty, please be informed that by law you are required to answer any question fully and satisfactorily. Of course, questions that are lawfully put to you, or to produce any document that you are required to do so in connection with the subject matter of the inquiry, notwithstanding the fact that the answer or the documents that you give us could incriminate you or expose you to criminal or civil proceedings or even damages. Mr. Chetty, you are, however, protected in that evidence given under oath or affirmation before a House or a Committee of Parliament may not be used against you in any court or place outside Parliament, except in criminal proceedings concerning a charge of perjury or a charge relating to the evidence or documents required in these proceedings. Please be aware that in terms of Section 17, subsection 2 of the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act, a person who willfully furnishes a house or committee with information or makes a statement before it that is false or misleading commits an offense and is liable to a fine or a term of imprisonment not exceeding a period of 2 years. You are required to take an oath or affirm that the evidence you shall give shall be truthful. Which one do you elect, oath or affirmation? You have elected to take an oath. May you please follow me as I dictate to you. May you please say aye and state your names in full.
Gishen Chetty,
Yeah. Let's repeat that, Mr. Chetty.
I, Kishen Chetty,
Swear that the evidence I shall give
swear that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
And so help me God.
And so help me God.
Thank you so much. I'm handing over to you and the senior counsel to start with the presentation of evidence. Can I check, senior counsel, how many hours do you need to conclude the presentation of evidence?
Chair, always difficult to predict, but I wouldn't expect us to be longer than 2 hours, if that long. As I said, you and the honourable members would have gone through this affidavit. It's lengthy, but it's full of technical, legal.
No, it's fine. If you need 2 hours, let me exercise my benevolence and say that you run until 13 hours. By that time, Mr. Chetty and senior counsel, you must be done with the presentation of evidence.
Thank you, Chair.
Do everything within your abilities to ensure that by that time you are done. Thank you.
Thank you. Thank you.
Let me wish you good luck. Thank you.
Mr. Chetty, you reference a number of cases in your affidavit. There is the Silverton case, which is case number 335/2/20, and then there's also a number of other cases.
Sorry, I don't understand.
Then there's also a number of other cases. Silverton case numbers, and Brooklyn case numbers. Now, in our discussion and in my understanding, you had initially been an accused with some 70 other accused, which is some 40 odd natural persons and 30 odd juristic entities, companies, CCs, in case 335. We can call it 335. That case, which is referenced in paragraph 1.1, honourable members, that case was in March 2021. It's 2021? 2020.
2020.
2020.
4th of June, 2020.
4th of June 2020.
Yes, we were arrested.
The case was struck off the roll.
No, it was struck off the roll on the 25th of March, 2021.
Yes, that's the one I'm referring to. March 2021. The case was struck off the roll in terms of section 3423, capital letter C, by the magistrate. Is that correct?
You're correct, Counsel.
And that's what we can call the big case, right?
Yes.
Subsequent to that, there have been several. You were arrested and charged in several other cases, which, as it were, mutates from this big 335 case. Is that right?
Yes, Counsel.
And those are the cases that we see referenced there: Silverton, 143, 145, 142, and Brooklyn, and 147. So those cases, they are taken from the big 335 case. Is that correct?
Yes, Counsel.
And your case is that in itself constitutes an abuse, because 335, in terms of 335, I think we know now from another experience with another witness, when we deal with 342, striking off, that it can be enrolled, but it can only be done if a certificate is issued by these days the National Director of Public Prosecutions, and that was not done. Is that right?
Yes, Counsel.
But I think in our discussion subsequently, you say that 335 has been reinstated.
Yes, Counsel.
Okay. So we also know from our consultation that you have brought an application to have these cases set aside on the basis, amongst other things, of an abuse of the process and unlawful interference in these matters. And that case is still pending in the High Court. Is that right?
Yes, Counsel. We're waiting for a judge to be allocated to the matter.
Yeah. So, and you appreciate and understand. In fact, you to your credit, you pointed out to me that you are not here to debate the merits of these charges against you. The charges in case 335 relate to theft, corruption, money laundering, and quite a number of serious charges. Is that right?
100%, Counsel.
You're not. You're obviously defending these charges, but you're not here to debate the merits of those.
No, no, I'm not.
Your complaint before the committee is you link it to the terms of reference of this honourable committee, and that is interference, unlawful conduct, unethical conduct on the part of the police, and you in particular point fingers at officers Baluchan, Shabalala, Perumal. Are they? Shabalala is a prosecutor, is that right?
Yes, he's a prosecutor in all my cases.
In all your cases?
Yes.
And Perumal and Baluchan are with IDHOC.
Yes, with IDHOC now, yes.
And Low, the other person?
Paul Lowe is an advocate that is at IDHOC.
At IDHOC.
Under correction, is Shabalala's senior.
Okay. And those, you say they the main actors in the narrative that is in your affidavit?
Yes.
But we also know now, in fact, perhaps tell us about the call you received yesterday from IPID.
Okay, Counsel. I opened a case 12/07/2022 Silverton case in 2022 after I realized that charges were taken off a case that was struck off the roll, 335, and it was duplicated in case 143, 144, 145, all Silverton cases. I then opened the criminal case. It was then taken to Gauteng province. Everything is in my affidavit here, so let me just talk about that case 12/07 as you're asking me about the call. I received the call day before yesterday from Mr. Beloy at IPID, because 12/07/2022 is at IPID's office now. And Mr. Beloy told me that the advocate from the DPP's office, North Gauteng, called him and asked him to come and collect the docket and obtain warning statements from these three individuals: Dylan Perumal, Sunil Baluchan, Richard Shabalala. And I then told Mr. Beloy that I will be coming here today, and he must please tell me, like last night, if he called him so I can put it on record here, because on my affidavit it shows exactly what has happened to this docket since I opened it in 2022 to where it is now. So Mr. Baloy did tell me that he contacted Sunil Baluchan and informed him that he needs to obtain a warning statement, and he couldn't get hold of Dylan Perumal and Richard Tyler Shabalala, reason being that they on leave. So that's where it stands now. But in my affidavit, it stipulates exactly from the time I opened the case, it went up to the DNC's office, up to General Libia's office at the Hawks, and it shows the abuse of power. Everything is in my affidavit. So on the call that I received yesterday, that's it. It's with Mr. Baloy now. The docker is with him.
So that case is also currently pending and being dealt with by IPID.
Yes, and just to bring it up, explain what it is. That case is what I'm here for, on the duplication of charges from the case struck of the roll to the baby cases that was opened. That is based. That is my complaint. That is 12 of 7, 2022.
Yes.
Yes.
Now, what would you want this honourable committee to do or to recommend some remedial action in view of the fact that your complaint against Baluchan, Perumal, Shabalala, and Low, those cases are being dealt with by IPID. You've also complained to some very senior SAPS officers about their conduct, that case is pending, and your High Court application to have these cases set aside, that case is also pending before the High Court.
Council, I would appreciate the committee to see or understand the exact abuse of power. This ADHOC officials, the courts, especially Palm Ridge Magistrates Court, Pretoria Magistrates Court, Pretoria High Court, on how these individuals bring cases on the roll as they please and not following the court rules, the uniform court rules of the court. Because I did a lot of background checking as we go through my affidavit. The committee chairperson will see what my allegations are, because I have all the next years of court books. We're appearing in court, but we're not registered on the court books. I have transcripts and so forth. So basically, it is on the abuse of power of these guys. And when I do complain about them, I'm getting arrested, or they're retaliating on me by using state machinery. And I have proof of all of that.
And your status currently is that of an accused in all of these cases, and you out of, sorry, thank you.
Thank you, Chair. I'm sorry to interrupt Mr. Orrington and Mr. Chetty. Chair, I've gone through this affidavit, and I'm very concerned that, well, I'm concerned about the contents thereof, and I'm concerned about why Mr. Chetty is here today. But I'm more concerned about the fact that he's not here with any representation, which is also a concern to me. Advocate Orrington is not his legal representative, he's the evidence leader. So Mr. Chetty is not his client, and he doesn't have to advise him in his best interests. But Mr. Chetty is the accused in a number of very serious matters that are currently on the roll or to be placed on the roll. They're currently in court. And I don't know if his legal representatives in that matter know that he's here. And I don't know if they helped him draft this affidavit. But my major concern is that we operate on a principle of innocence until proven guilty in this country. But he stands an excellent chance today of doing himself a lot of damage in those matters that are on a criminal roll. And that's really something serious that he should think about and we should think about. Because he's just said he's here for 2 matters. Well, that's not really why he's here. Now that he's here, we can ask him about whatever we want. And he's obliged to answer. He may well find himself in a position where he has to incriminate himself. He's not represented. He's got no one to advise him. It's not our job to advise him. So I'm concerned about what we're busy doing here today is, for me, not quite right. But I'm also concerned about his position in terms of his constitutional rights and his right not to incriminate himself. He's not a lawyer. He's a businessman. As he says, not doing business at the moment. So those are my concerns, Chair, and for me, they're serious concerns. Thank you.
Let's see. What is your response?
Honourable Chair, as I indicated in some introductory remarks initially, it was Mr. Chetty's father who had lodged a complaint, but it was about the conduct of a curator in a matter. I'm not sure whether it's in relation to one of these criminal matters, but I know they're also facing some charges which the investigating officers say emanate from tax fraud. But subsequently, only last week or the week before, a substantial affidavit was sent to Mr. Romano, which was then passed on to us. And we were required to consult with a witness initially. Advocate Mkhize was going to lead Mr. Chetty's evidence, but you'll recall that on the day, I think it was last week, we either couldn't accommodate him, and he was he's come back. The concerns raised by Honourable Breytenbach are shared by us, and that's why I indicated also at the outset that I will try and make sense of what's in this voluminous affidavit, and I'd also asked what, if anything, this Honourable Committee can do other than what I did, which is to read the affidavit and listen to Mr. Chetty very sympathetically. According to his narrative, he seems to have been badly treated. But again, it's just one side, or one side of a story, and I'm not sure that there's anything we can do about this other than to note his claims, and I suppose significantly the names of Baluchan and Perumal and some of these officers, their names have cropped up in some other matters from other witnesses. So that might indicate some kind of pattern. But the fact that IPID is now investigating the case that he has brought against them, the fact that there is a High Court matter that's pending and awaiting the allocation of a judge, where in the correct forum, a judge will, having heard argument from all sides, from both sides, will make a determination whether or not these cases should be dismissed, and the prosecutions not proceed, which I'm not even sure that a judge can do, given that these are all matters that's pending before different courts. So all that I'm saying, it wasn't for us, Honourable Chair, as evidence leaders, to make a call and say, no, we don't think you need to hear this witness or listen to the witness. It's going to be a waste of time. We were asked to consult with him, to interview him, and we are here now today. other than in summary to say, I think the concerns raised by Honourable Breytenbach are valid concerns, and that perhaps the better thing or the better course to take is to note what's in his affidavit when the committee comes to its deliberations, and to take serious note of some of these allegations, which some of them are quite hair-raising. These Silverton and Brooklyn cases, they arise from this big 335I case, as he called them, baby cases, and it's been done selectively. But again, it's either for the trial court to make that determination. I don't think we equipped. Maybe Honourable Breytenbach is in a former job, but we're not equipped to, or maybe Mr. Novalo as a practitioner. Thank you, Chair. I'm sorry if I'm not being particularly helpful.
Yeah. No, let's do this now. Okay. Can I hear you?
Thank you, Chair. Yes, Chair, in the defense of senior counsel, he is not known for being a criminal lawyer. His expertise lies elsewhere. I honestly submit, it's my view, that we're about to seriously prejudice Mr. Chetty. Whether he realizes it or not is not really relevant. We're about to do serious damage to whatever case he may have. And I would urge him to not proceed with this. We can take note of this affidavit. There is stuff in here that is concerning, but we can read it. If he opens himself up to questioning, Chair, I foresee serious problems that I'm not entirely sure that I'm comfortable to participate in. Because once he does that, it is our job to question him, and he will really not come out of it well. And it can only prejudice his case. I don't know if his lawyers know that he's here. Certainly if he was my client, he wouldn't be here. And this, the contents of this affidavit, apart from the suggestions that there is foul play with the investigators mentioned, which we already have heard of them and we can take note of and look into, the rest of it is not relevant to this committee's inquiry, in my view. And so we're going to spend a day trawling through, with respect, irrelevant information, not even evidence. And it's the prerogative of a prosecutor. It's not this committee's prerogative. It's not even the court's prerogative. It's the prerogative of a prosecutor to charge people as and how they wish, and to group charges as and how they see fit within the prescripts of the Criminal Procedure Act. It's a very difficult thing for anyone to interfere with, because there's a certain game plan. Of course, every accused is entitled to be charged with everything at the same time, if it happened at the same time and place under similar circumstances. But if not, no. The prosecutor charges in the fashion that they see fit, and nobody can interfere with their discretion. So this committee certainly can't. We can't help him with that complaint. Richard Shabalala is a prosecutor of many years' experience. Paul Lowe is a prosecutor of some 40 years' experience. They certainly know their way around a criminal court. And I'm sure that they're both watching TV right now, waiting for the questions to come. Because please believe me, they will use it against him. And there's nothing to prevent it being done. I really urge us to reconsider what we're busy with here today. Thank you, Chair.
Can I rotate to honorable members in here?
Thank you so much, Chair. I think what Honorable Breytenbach is raising, Honorable Vessels would have shared it with me yesterday. And unfortunately, the same concerns that he would have raised yesterday, I didn't get an opportunity to look at the affidavit at that time. But I think it's quite concerning, one, when the evidence later says the actual complainant is not the person who's in front of us. Someone else submitted the complaint, but someone else is appearing before us. Maybe the evidence leader would actually explain to us, boss, if I hear this properly. He actually says, I'm not sure the father submitted, something like that. But as I say, he will actually explain further so that for our understanding of what he's saying. To Chair, I think it's important. It would have been raised by members on our housekeeping committee meetings that between the evidence leaders, the legal unit of parliament, and the secretariat, there must be a way of checking unto the nature of the people who apply to appear before this committee. Because it's quite cumbersome now. If every now and then we are to discuss in this setting, in the presence of the person who would want to come and present to us in front of South Africa, that no, this person was not supposed to be here. The nature of that which is submitting to us was, it would, in our view, Chair, that they would brief you about the nature of that particular submission. So that you come to the committee and advise the committee better, so that the committee takes a decision whether to invite or not to invite that particular witness. But it's becoming a problem. Now, we agree, Chair, the nature of what is said in the affidavit requires a competent court of law. And it's a detriment, it's a legal detriment to Mr. Chetty himself to come and answer here. And you'll recall, Chair, we would have said, in a number of witnesses, they are not at liberty to come and tell us what to ask and not what to ask. But when the evidence leader and Mr. Chetty are starting interacting, there is already a condition that I'm not prepared to answer this matter and this matter, then this matter, because it's in court. Now, consistency compels us to say, we have said to General Patlane, we have said to so-and-so, that they are not going to put forward conditions for us to proceed. Now, part of what we pick up from Mr. Chetty's argument in the affidavit is that there are people who are charged by the state to preside or process his cases, which some he accuses of them having been convicted before, both at ADHOC and some having been subjected to an internal DC of SAPS. That's a matter, Chair, that I think if we agree on an approach, just to say from ADHOC head and SAPS, give us a status of so-and-so, whether or not they got charged, whether or not they were disciplined, whether or not they were convicted, and all those things. But it still matters that Mr. Chetty and his legal representative must raise in a court of law that the nature of how the state has processed my cases has got these irregularities. So I believe, Chair, and we agree from where we're seated, that it's not only a problem of the committee, it's majorly the problem of Mr. Chetty to come and divulge some of the issues in this particular platform that are still subject of a competent court of law. We'll all agree, Chair, that the rules of the National Assembly do not allow us to get into the merits of issues that are still sub judice. So I think, Chair, we must plead with Mr. Chetty, and I'm worried. This may appear as though that we don't want Mr. Chetty to come and talk to us. We'll recall that this is the second time we're discussing his matter, and I'm asking him to go back and come back and all that. It may appear, Chair, that we don't want Mr. Chetty's testimony and all that. But the major concern is that we are to respect the state process and the judicial process. And we are not willing to be part of ruining his case and his presumption of innocence. So it's us pleading with him that he must reconsider, then we'll take it from there. Thank you very much, Chair.
Honorable Nomvalo.
No, thank you, Chair. Chair, initially when Honorable Breytenbach was raising the matter, I was agreeing with her overwhelmingly. But there's an aspect which I don't agree with. When she wants to project certain people against whom complaints have been laid in this affidavit as a paragon of virtue. He's even citing their experiences and so on. I think that is unfair, and that is being argumentative against the witness before us, because we must be fair to witnesses here. Allow a witness to present, and then when he has presented, you make your arguments. Not to say when a witness has not even opened his mouth, the people that you are complaining about are competent people, they have experience and so on and so forth, as if the witness is hallucinating. That witness is raising these complaints out of frustration. I understand the legal aspects and the legal concerns that Honorable Breytenbach is raising, and I agree with them to say it's going to be prejudicial to the witness when he deals with matters which are before court or which are pending, because even with us, it's going to be difficult to interrogate his testimony, because we will interrogate it with caution. We won't understand to which extent we should go, because we will be trying to save her, and we will be trying to save his right to be innocent before, to be presumed innocent before he's proven guilty. So, but the problem here, Chair, is that our house is not in order. It goes back, and I'm afraid now that witnesses or members of the public largely are going to be on the receiving end of our demise as the committee. But that demise is orchestrated by the legal team. We raised this thing in one of our meetings, Chair, and we asked a question that, what is it that a witness with the evidence leader do during consultation? What are they doing? If here in this committee, we deliberate on issues that are supposed to have been dealt with during that consultation, because they have been employed to do exactly that, to say this evidence by its nature does not belong to a committee. Maybe you must submit a written statement, or maybe you must apply to tender this evidence in camera because of its nature. That guidance is supposed to be tendered during that consultative process, but it does not happen. What are they doing? Maybe Advocate Arenzo needs to tell us. What are they doing during consultation? Are they guiding witnesses on legalities or not? Or they just accept, they just say, no, bring everything, we'll just pass it as it is to the ad hoc committee. So I'm very worried, Chair, in as much as I agree with Honorable Breytenbach that now we want to turn away a witness who has come here under an impression that he's going to get an opportunity to explain his side, and who was going to do otherwise if he was properly guided by the evidence leader. So he has been failed by this committee. He has been failed by the evidence leader. And now we want to suffocate him. We want to turn him away. He has compromised all his schedule to come before this committee and argue for his case. When we are here, I understand, members, because we knock off at night here, so we don't get time to read these statements. I've only read it now when I'm here. And I'm getting concerned as I'm here as to what is it that we're expected to do here when a statement from page 1 until the last page talks about cases which are pending before a court of law. So what are we expected to do as members of this committee? So, Chair, I know we're towards the finishing line. We're at the tail end of this process. But our concern remains very high against the evidence leader and his team on how they conduct this work. They are not doing their job during consultation. That is why sometimes we read 180 pages, which is full of irrelevant content. Because during consultation, they must say, no, this one, Advocate Patlane, when he was here, was told by members that, no, these are labor issues. Those are the issues for which he was supposed to get guidance during consultation. To say, no, this one does not fall within the terms of reference. It must not go to the committee. Because he has been employed to do that. So, Chair, unless the witness before us feels strongly that he wants to continue under the guidance that we have given him, or even after the concerns have been raised about the risk he is imposing himself to, we are saying we're of the view that he must submit rather a submitted statement, a written statement. It's unfair to say he must not submit anything at all because he's complaining about the judiciary here. So when you say the matter is under a competent judiciary, we are already making a judgment that all the complaints he's raising are invalid because the institution that he complains about cannot help him if he feels that it is compromised. How can you complain to the same judge that you are complaining about, to the same magistrate that you are complaining about? So let the client not be helpless. Let's not make him vulnerable and say, no, go away with this statement, we can't help you. If he continues to feel strongly that even after this he can continue, it's fine, he can continue. But as this committee, we have been honest to him to say this is prejudicial, but if he wants to continue, can continue, Chair. Thank you.
Honorable Breytenbach,
Chair.
do you want to speak?
Oh, yeah, Chair, just on one point, I didn't mention Shabalala and Lowe to suggest that they're untouchable. I mentioned them to suggest that they have a lot of experience and they will be watching this because it's an opportunity they wouldn't let go by. Not any other reason did I mention them. Yeah.
Okay. The EFF?
And Chair, I remain deeply uncomfortable with the process.
Okay.
I'm not sure that I want to participate.
Sure.
Thank you, Chair. Hey, it's embarrassing. We are an embarrassment to the people that have elected for us to serve here in Parliament, that we can even sit here and while after a witness is even sworn in, that we raise things that should have been resolved a long time ago. I echo my colleague's point of the issue of resources for this committee. I disagree with him that we must put the blame squarely on the evidence leaders. Literally, we have 3 evidence leaders. If you go to that commission, who's pretty much has the same number of witnesses that we are dealing with, they have like a whole team. Our legal team here, our technical team here, they're not here full-time, Chair. And we've been raising this for a very, very, very long time. We even got a letter, or finally the letter was circulated on why we don't even have a forensic investigator. We are an embarrassment to the people who voted for us. Parliament is an embarrassment not to provide adequate resources. And it's got absolutely nothing to do with the fact that we don't have money to be able to serve South Africans with the dignity and the efficiency that we need. It's just embarrassing. And on the merits of what has been raised here, I think it's highly disingenuous to talk about active cases. Pretty much every single person that has come here, senior officials of SAPS, they have active cases. It's not going to be the first time that we've had witnesses, even in committees, where they say, I can't respond to that because it's in court. So to all of a sudden feel uncomfortable participating because someone can be prejudiced is, I don't even know where we're pulling that from. It is something that goes on here. It's even weaponized in this parliament, even in committees, that we shouldn't ask that question because that question is going to jeopardize the case. We hear that. It's a long sing-song story. Mr. Chetty has been here. This is his second time. The first time we even sent him away. The fact of the matter, whether this is related directly to our terms of reference or not, it's a bit late. So unfortunately, we're going to have to take his case. There are matters of SAPS that are involved in here, and we are going to hear because we are the People's Parliament, and there's nothing in here that's not related to SAPS. It might not speak directly to the terms of reference, but we are here. We'll hear from Mr. Chetty if he's going to feel like he's compromising his active cases or not. But the story of that prosecutors or whoever's going to be prosecuting his case are listening and is going to be prejudiced, I don't see how that has any relevance here at all. Everybody comes here and they say, I can't answer that because I have an active case. And we allow it. It happens many, many times. So it's up to Mr. Chetty. We are here. It's our fault here. We've let South Africa down. And Mr. Chetty will make the call. Thank you.
Bangazita.
Thank you, Honorable Chairperson. Yeah, I also do feel that it is unfortunate that we are engaged in such a discussion at this point. In fact, midway through the presentation of the chief evidence by Mr. Chetty, it's something that we should actually have dealt with before he came here. Now that he is here, and there are concerns about incriminating himself on some of the issues because most of the matters that he is actually presenting here are before court. I don't see how that is different from General Pahlane's cases, for instance, because he also had a string of issues that court as I speak, and but I don't see any difference between Mr. Chetty's case and that of General Pahlane. So I feel it's up to the witness before us to decide what he wants to do. If he feels strongly that he needs to continue to ventilate his frustrations before this committee, so be it. Thank you.
Honorable Sols. May you switch over? May you switch off Bangazita?
Thank you, Chair. Look, I have many issues with our legal team, and sometimes with how logistics are handled with evidence or witnesses, etc. But today is not one of those days. I feel that this committee is wrong to, one, blame our legal team and the evidence leader. I disagree. And two, I further disagree that Parliament is an embarrassment. That's not the message we must send to the country. Indeed, we have limited resources, but we must be honest about what has been done with the resources that we have. We have our evidence leader. We asked for a forensic investigator. You wrote to the Speaker Chair. It's not like it was ignored. The Speaker responded. The Speaker said, we have Advocate Umkhize who has forensic investigating skills, and she was intentionally appointed because she has that skills. And that replacement was because she possesses that skill. So now, with the limited resources we now have someone here with the investigation skills that we require. So we must not make it look like we are not operating properly here. We are doing the best we can. So I disagree with that position. On the evidence leader and the witness before us, when the witness was here the first time, the evidence leaders was prepared to hear him. It is us as the committee who then asked of Mr. Chetty, because he said he realized that in consultation, the brief consultation they had, all of his attachments was not there. Then, Chair, you ruled that that would be unfair, so you gave it days to say, go get all the attachments to be fair, and then you come back. The evidence leaders follows our mandate. They go and they do that. Now they come back after days. They have the attachments. The evidence leader is ready to lead. We now blame the evidence leader for a mandate that we've given. We don't know Mr. Chetty, but we try to treat everyone in the same way. Lastly, in terms of our terms of reference, what are we meant to do? We are meant to hear anybody that says they can help us to get to the truth around infiltration, political interference, and defeating the ends of justice. We must test that. We did not invite Mr. Chetty. Mr. Chetty offered his information. So let him bring the information and let us test whether it helps us with our responsibility here. So I don't feel that the committee is in a bad position here. Number two, on the issue of Mr. Chetty incriminating himself, we must ask Mr. Chetty, we must give him an opportunity to say, and you must pose the question directly to him. Given the risk that you are potentially going to incriminate yourself by what you are going to present to us, we must ask him, are you willing to take that risk to potentially incriminating yourself by the information? If he says yes, that's consent. What must we do? We will then ask him, we will interrogate him. If he goes to jail because we asked him and he's found guilty, he's found guilty. He must go to jail. We won't visit you, Mr. Chetty. We will be glad that we've contributed to whatever the court will find if you are found guilty. But we can't sit here now and try and protect potential things. We must do our jobs. Just make sure, Chair, that we have his consent on record, that with all the information, he's still willing to testify, and then we go ahead.
Thank you.
Thank you, Chair.
Honorable Vessels.
No, thank you very much, Chair. No, I share the concerns, and I've also, as honourable colleague said, I raised the concerns last night. I raised the concerns with regards to other witnesses before as well, and it's always met with, but we should be the parliament of the people and open to everybody. But, Chairperson, we do have a responsibility to protect Parliament from becoming a kangaroo court. I do not agree that it's the choice of Mr. Chetty if he is comfortable to continue or not. We should make that decision because we are at risk of and the problem lies with what the Honourable Souls say. We must test it. If we test the validity of the allegations made by Mr. Chetty, we're going to have a problem. The Honourable Matthys says that he can exercise his right to say, but this matter I won't respond to, it's in front of the court. Then we can just as well stand up now and leave, because everything that is alleged is in court, because even the allegations made are now in front of IPIT. And the witness already attested to that now and said that his allegations with regards to the alleged wrongdoing in terms of these cases are now investigated by IPID. So we are in a peculiar situation where the relevance of this is also it's really not relevant to our investigation currently. What is relevant we can take note of, as other colleagues said in the statement. Mr. Chetty is here. He confirmed that this is his statement. Let's take note thereof. Let's protect the integrity of this committee, but also of Parliament. And if we are going to go ahead, Chairperson, I'm very uncomfortable to participate. But Mr. Chetty must then also know that we are also in possession of an affidavit by Brigadier, he's now Mr. Raman Jalam, who is in prison currently, who's a co-accused in many of these cases. We have that affidavit. If we're going to test the validity of the wrongdoing, we can't do that without exploring also the counter allegations and the evidence that's also provided that says it's the contrary. And then we are exactly where the Honourable Breytenbach said we are going. And we are not a court of law. These cases are in the court of law. Let the court of law decide what is wrong, who's guilty, and who's not guilty. Thank you, Chair.
Good morning, Honorable James. And
Hi, good morning, Chair. Finally. I strongly agree. We had this discussion, like Honorable Vessel said, we had this discussion later last night when we left. And I think it's just shocking right now. I always look at matters and I put myself out there and I think, what would South Africans be saying right now about us? I think that's almost the most important things that comes to mind. These people have brought a witness before them twice. And today they start off proceedings by debating whether he should be here or not. That is a disgrace. That is an embarrassment. I think the evidence leader have been subjected to this, to his statement. And I think they should have guided and advised this committee on the best way forward. I genuinely believe, Mr. Chetty, that you will compromise your cases if you proceed here today. And therefore, I also state that as Action SA, we're also a little bit uncomfortable with proceeding. Thank you.
okay. Before I give the evidence leaders and Mr. Chetty to make statements, let me say this, that I understand that when you are members of parliament, you are politicians, and parliament is a political institution. And today we want to discuss a procedural matter, and a procedural matter which is clouded by politics. Number one, who brought Mr. Chetty here? Mr. Chetty was brought here by the committee. It's a decision of the committee, Mr. Chetty, that you must be here. And there is nobody who is going to pass the bag and want to blame the committee secretariat or evidence leader. The committee in its own meeting took a conscious decision. Ramano was there, gave us a report. So we must take responsibility, honorable members. I always tell you when I'm here that the chairperson speaks the decisions of the committee. And if you listen to the summary that Honorable Sols gives here, Honorable Sols has given you the whole summary of what the committee has done. This committee further, Honorable Sols has said that the public submission evidences will not be led by statements which they would have prepared with the witnesses, but the witnesses will bring their own statements here. The public submission witnesses. Mr. Chetty has brought his statement. Why do you want to hold evidence leaders responsible for a statement that you said public submission witnesses must bring their statements before the committee? He brought his statement. And so what the committee has to do is to look for the needle in the haystack, separate chaff from grain. If you know what your terms of reference are, go through this whole statement and then look for what is relevant to your terms of reference than to prejudice the witness, either through the committee process or through any legal process. We run an oath every day here, and the honorable members are the ones who must know the oath more than the witnesses. Because the oath here says that any information or evidence or document that the witness presents before the committee cannot be used against him anywhere outside the House of Parliament or a committee of Parliament, unless in proceedings of perjury. Because when he's here, he's protected by the same provisions of the Act that we read to him. That's what it is saying, the oath that we take here. Unless if I'm giving it a different interpretation. But what is being said here is that the information cannot be used anywhere outside Parliament or... But the long and short of it, honorable members, is that this man did not come here, this witness did not come here by his own accord. He is a decision of the committee, and the Secretariat has even reported before us. You know what happened? When they reported that the person who made a submission before the committee cannot be found, it was this committee which gave the Secretariat details to say, go and call these people. These are their details. And they went there and did exactly what you have instructed them. It was this committee, it was nobody, it was not a member of the Secretariat or the evidence, it was the committee that presented contact numbers, digits one by one, in a committee meeting to say, call them. And they went out and called Mr. Chetty, he came. He's here now. So there is no way we are going to be temerarious here and try to gerrymander our rules. We are going to proceed with Mr. Chetty, let him present what he wants to present before us. And after he has presented, if you decide to keep quiet, and I will release him to leave and go back home. Thank you so much. We are going to proceed, no further discussions on this matter. Can we proceed, Advocate Arendse?
Thank you, Honorable Chair. I suppose that's the end of that discussion. I can't say anything further as the evidence leader about the process that brings witnesses before this honorable committee.
Don't comment on that. The chair has
Thank you.
has made a political statement. I don't want to put you on the crossfire. Honorable Sangweni.
Thank you, Chair. I also don't want to get caught in the political crossfire. Chair, can I ask, so we don't have this issue tomorrow? We're having 3 public participation witnesses. If my memory serves, there had been an issue that I'm not sure is Nicolette Ms. Prinsloo had raised about some of these witnesses, including Mr. Chetty and one witness that we are meant to see tomorrow. Can we request that before we maybe even break for lunch, that the Secretariat advises us on the witnesses of tomorrow and if indeed those witnesses should be? Because we had been advised against, Chair. Thank you very much.
Yeah, no, those witnesses are coming tomorrow. They are a decision of the committee, honorable members. Whether they come here to say anything or to say nothing, the committee has said they must come. So we are not going to change our decision at the 11th hour. We unless that they are unavailable, but any of those witnesses who is available for tomorrow, they are going to come here. Honorable Vessels.
Thank you, Chairperson. I just think it's important that we just remember that when the committee decides on the witnesses, we don't have the details, the statements, and the actual detail of what the case pertains to and what the witness is going to present to us. We raised the issue last week on when we received the statements of tomorrow's public participant witnesses. We raised the issue and we said we must look at that and the legal team must look at that because it does not seem relevant. And I repeat that, Chairperson, that I think we should, I support the Honourable Sangoni because they should look at that before those witnesses travel. And Chair, the same with this. I do not accept, with due respect, your statement that we decided. We did not have all the facts when we took that decision. When we get the facts, we can revise a decision.
Yeah.
Thank you, Chair.
No, I hear you. But what is important, honourable members, you did not only decide. You decided and further instructed the evidence leaders that the public submission witnesses must bring their own statements here. Yes, maybe what we should be saying is that we could have said that let them look at those statements and advise the committee. But you said that no, they must bring what the evidence leaders do. They study the statement of the witness and look at how they can arrange it thematically. But without changing the whole statement or saying this must not go before the committee. So you can't want to apportion a blame on them for doing what the committee has instructed them to go and do. Honorable Nomval.
No, thanks, Chair. I hear your ruling on the matter. I disagree with you vehemently. We agree on witnesses, not on statements. We don't consult with witnesses. Witnesses consult with the evidence leader, and for a purpose. They don't consult with us. So it's wrong for us to be blamed for the work of the evidence leader. I still insist that the content of the statement, a person who can guide the content, is the evidence leader. If it's not him, then who? Because by saying, Chair, witnesses can, public participation can bring their own statements to the committee. We're not giving an open-ended directive. That must be within the terms of reference, and because it means tomorrow we're going to wake up with a Bible here. A person who decides to submit a Bible to the committee and say, no, it's you committee members who said public participation can submit anything. No, there is guidance that must be provided by the evidence leader. I still insist you can defend him if you like, but I still insist, Chairperson, that the reason why we have the advocate here is for quality assurance. He must exercise his responsibility to say, this is relevant, this is not relevant, this is within the terms of reference, this is outside the terms of reference, not us. Because if you are putting the blame on the committee, then allow the committee to consult with witnesses on their statements before they appear here. We get statements here in the morning. So we give a go-ahead under an impression that further work will be done on the nitty-gritties by the evidence leader, not by the committee. It was going to be a different case, Chair, if when we make a determination, we make a determination with a statement of a witness at our disposal. To say, if they can submit statements to us and say, this is what the statement want to present, then take a decision of whether he must come or not. Then we can be blamed for the content of the statement. But we make a decision on the basis of what has been presented to us by the evidence leader, because when they present, they say, no, this witness wants to come and testify on A, B, C, D, and E. then we say, no, it's fine, we can go ahead. But there is no statement at our disposal. So I disagree, Chair. That is our strong view. But if there is an appetite of defending the evidence leader, then that's not my baby. It's fine, thank you.
Let's proceed, honorable members. No, we are proceeding. Let me tell you how we are proceeding. The statement that you have before you, it's not a statement that has an input of the evidence leaders. You know, when evidence leaders consult with witnesses that you have identified who come before you, they draw statements. Some witnesses sit with their lawyers and draw statements and they submit to the evidence team. And the evidence team, when they lead evidence here, they select thematic areas on which they are going to lead evidence. So the statement that you have before you is not a statement that was written in consultation with evidence leaders. And that was your decision, that the evidence leaders have given you a statement that the witness has brought before them. And they have prepared their own notes on how they are going to lead evidence. So let's allow the evidence leaders to follow the thematic areas that they have prepared. And it's up to us as the committee to look at what is relevant to our terms of reference. Honorable Sols and then Honorable Breytenbach, you are the last.
No, Chair. maybe we must submit Bibles so that we can be reminded to be truthful. As the committee, even those public participation witnesses that's coming tomorrow, Honorable Vessels and Honorable Novalo must be truthful. We received it from the public. We brought it to the committee. The committee said, in the next meeting, table what is the content so that we make a decision. In the next meeting, I read the emails. The decision was made on the basis of that submission and a condonation was given. That's where we come from to this point. Then they had to provide their information. And now it's a matter of you must test what is in there. We must test it here. Whatever they present to us, are they giving us content that will assist us with our work? So we must not be untruthful and say we had no sight. This is public participation. It is not like the witnesses that is brought to be led by the evidence leader. So we are not defending the evidence leader. We are saying, and the secretariat, we are saying there are many things that we are dissatisfied with and we raise it. But today, this time, it is wrong to say the blame is on the secretariat and on the evidence leader. It is wrong today. Thank you, Chair.
Honorable Breytenbach, you are the last.
Thank you, Chair. I'm not blaming anybody. We find ourselves in this situation. I choose to deal with it as I find it. I am deeply uncomfortable with proceeding and I request to be excused along with Honorable Karabon.
Okay.
Thank you.
Mr. Chetty, are you ready to proceed?
Chairperson, I am ready. Thank you.
Okay. Thank you. Thank you so much.
Chair, we didn't hear. You must please let him state for the record he wants to. Knowing the information and he's willing to do it despite what he knows.
Did you hear what Honorable Sources? Can you raise your voice and put it on record? Are you willing to proceed?
I'm very willing, Honorable Member.
Okay. The honorable members have requested to leave and you occupy their seats.
Chair, you must say which honourable members and from which party have left proceedings. Because we've had so many people come here and they just tell us, I can't answer that, and nobody leaves. So we don't know how all of a sudden now there's a different stance of not wanting to be part of things. So please let it be clear, Chair. Thank you.
Yeah, I mean, it's it's unfortunate, but sitting here as the chairperson, I don't have any authority to detain persons in this meeting, members of parliament, including witnesses. That is why the last time when we saw a witness standing up here and leaving, the least I could do is just to say, hey, Mr. Lkhanyane, ayo, Eloi, Eloi, lama sawata, Lkhanyane, Eloi. There is nothing I can do. I can only say, why are you abandoning me? There is nothing more. So we are going to proceed, honorable members. Let's be humane enough. Mr. Chetty was here last week, and he spent the whole day with us. If you remember the time we made a decision that he must leave, it was towards the evening. And he spent the whole day trying to work on his statement so that it could satisfy the committee. And the committee met again, Mr. Chetty, on Monday and agreed that you must come today. You are here. We want to thank you so much for once again making yourself available, because we strongly believe that you have issues that you want to raise with us, and you believe they can help us in our work. So we are going to afford you that opportunity to raise whatever issue that you want to raise. You are under oath. We have read you the privileges that you enjoy here. I do not know, but that is how I understand the act, the provisions of the act that I have read to you. But because I'm human, I can have limitations, and I'm not infallible. If the provisions of the act that I have read do not cover you, I want to put it on record that you can't come and say the chair said this and that in the proceedings, and you want to use me as a defense. I think what must guide us here is that we are a constitutional democracy underpinned by what we call the trias politica, the doctrine of the separation of powers, that we do not make a call on judicial matters. The judiciary is the competent authority in terms of the doctrine of separation of powers that makes a call on judicial matters. And if you appear before a court of law, and the court of law says, but when you appeared before parliament, this is what you said, and they want to use that as evidence, they are the ones who are competent to make a decision whether the evidence you provided here in parliament is also admissible evidence in a court of law. And you cannot use parliamentary processes or mechanisms as a defense if there is a strong legal sentiment in the country that the evidence could be admissible before any competent court. So I just felt I must make that statement, because law is science, and science can be subjected to different interpretations. Like you see, when we are here in Cape Town, the direction of the sun is not as I know it in Limpopo. That is science. So it can be differently interpreted, but at the end of the day, it remains the same sun with 12-hour day and 12-hour night, whether in Cape Town or in Limpopo. So let's have that understanding. So you said that you want to proceed. We are going to proceed with you, and Honorable member has reminded me here that some of the witnesses who appeared before us, when there were matters that were still before the courts, they will respond by saying, I may not be able to respond to this question because it is before the courts. You get it? Yeah, so that you have rights as a citizen of this country. There may be a burning desire in you to share very important information with us, but your rights must not be trampled. And whatever case that you have before the courts, your chances must not be jeopardized because we would have asked you questions and maybe out of excitement or agitation, you end up responding to those questions and they jeopardize your chances. I just felt I must say those to you so that you can frame yourself in such a way that as a citizen with full rights, you have prepared yourself, you know what you want to come and say before us, and what you think can help us to further our terms of reference. Thank you so much. SC.